At exactly 10:30 a.m. Eastern Time this morning, the Supreme Court of the United States issued a ruling that was as brief as it was powerful. The decision contained only 2 words: application denied. There was no written opinion, no explanation, and not a single dissent from any of the 9 justices. Every member of the court agreed unanimously. With that one sentence, months of aggressive legal maneuvering and delay tactics came to an immediate end. What makes this ruling remarkable is not its length, but its timing. The Supreme Court's decision came exactly 72 hours after a confidential legal agreement was submitted by Melania Trump's legal team to federal prosecutors. This agreement, known as a proffer, outlined the evidence she was willing to provide in exchange for potential immunity from prosecution. When 2 major legal developments happen just 3 days apart at this level, timing becomes impossible to ignore. This is not speculation, gossip, or politically motivated rumor. Everything discussed here comes directly from public court records. These include sworn legal filings, official agreements submitted to federal prosecutors, and formal Supreme Court orders. None of this information relies on anonymous sources or leaks. It is documented, verifiable, and now part of the legal record. The most significant development revealed by these filings is that Melania Trump has voluntarily waived spousal privilege. Spousal privilege is a long-standing legal protection designed to prevent one spouse from being forced to testify against the other. The principle exists to protect marital privacy and trust. However, under United States law, that privilege belongs entirely to the witness spouse, not the defendant. If the witness spouse chooses to waive it, the defendant has no legal power to stop that testimony. According to the proffer agreement, the evidence being offered falls into 3 main categories. The first category involves financial documents, most notably joint tax returns signed over a 6-year period. These returns allegedly reflect knowledge of property valuations that were reported differently depending on the audience. When properties are valued higher for banks to secure favorable loans, but valued lower for tax authorities to reduce tax liability, that pattern is central to both bank fraud and tax fraud cases. Signing a joint tax return carries serious legal consequences. Both parties sign under penalty of perjury, confirming that the financial information is accurate. Prosecutors rely heavily on these signatures to establish awareness, intent, and shared responsibility. According to the proffer, these documents place the witness directly inside the financial decision-making process. The second category of evidence consists of communications. These include emails, text messages, and recorded phone conversations discussing property values, loan paperwork, and discrepancies between figures reported to banks and those reported to tax authorities. Some of these communications reportedly occurred shortly before meetings with lenders, suggesting coordination and intent. In federal prosecutions, such communications often form the backbone of fraud and conspiracy cases. The third category of evidence involves witness corroboration. Melania Trump is prepared to testify under oath before a grand jury, confirming statements already provided by accountants, bankers, and property appraisers. Corroboration is one of the most powerful tools available to prosecutors. When multiple witnesses independently describe the same events and those accounts are supported by documents and recordings, defenses become significantly weaker. Because the Supreme Court rejected the final emergency appeal, there are now no remaining legal options to block this testimony. No further appeals can be filed. No procedural delays remain. The grand jury is now free to hear testimony, potentially within days. Adding urgency to the situation is the broader political calendar. A confirmation hearing for her former husband's cabinet nomination is scheduled for early March, approximately 6 weeks away. The overlap between criminal proceedings and high-level political processes dramatically raises the stakes. To fully understand the gravity of this moment, the exact sequence of events matters. On Monday afternoon at 2 p.m. Eastern Time, Melania Trump's legal team submitted the proffer agreement to the special counsel's office. A proffer is essentially a preview of cooperation. The witness explains what evidence they possess, what testimony they are willing to provide, and how that information fits into the broader investigation. What makes this proffer extraordinary is not the legal mechanism itself, which is common in federal cases, but the identity of the witness and the scope of the evidence being offered. Within just 24 hours, on Tuesday afternoon at 2 p.m. Eastern Time, the defense team filed an emergency appeal directly to the Supreme Court. Such appeals are rare and typically take weeks to prepare. The speed of this filing strongly suggests the defense anticipated this development and had prepared for it in advance. The emergency appeal asked the Supreme Court to block the grand jury from hearing spousal testimony, arguing that it violated marital privacy protections under the Fifth Amendment. On Wednesday morning, the Supreme Court officially docketed the case, but declined to issue a stay. This detail is critical. A stay would have frozen the legal process while the court considered the issue. By refusing to issue one, the court allowed the investigation to continue without interruption. Historically, when the Supreme Court believes an argument has merit, it often issues an immediate stay. When it does not, that silence sends a clear signal of skepticism. That skepticism became explicit the following morning.